Hi, my name is David Shapiro, San Diego-based criminal defense attorney. Today I want to discuss with you specifically allegations associated with what's known as date rape. There is no specific penal code section in California that addresses date rape. It's generally addressed under Penal Code Section 261, which is rape. Date rape we've seen in the news on a lot of high-profile cases within San Diego, within California, within the United States, drawing a lot of attention over the past couple of years, whether it's people who meet on social networking sites, people who meet in a bar, people who've been dating for years. The bottom line is if there's an act of sexual relations that are non-consensual by one of the parties, that's usually what's commonly referred to as date rape, and that is something battery under the law. So the essential element is obviously a sexual act without one party's consent. The first element of the offense is that something actual happened, a physical sexual act. So my advice always to people is don't even corroborate that there was any physical relations. I'm not saying lie about it. I'm not saying fabricate it or minimize it. You don't have to answer those questions, because if you go out on a date with someone and they then file a report of rape and they say, yeah, we went on a date, we had a good time, and then he forced me to have sex with him, or he made me do this to him or whatever. And if you're like, yeah, we went on a date and we had relations, well, what have you done? You've already got them about halfway to where they need to be in order to get a conviction. Then the only issue is consent. But if you keep your mouth closed, they not only need to prove that it wasn't consensual, they need to prove that something actually happened. So when accused of date rape, it is essential to keep your mouth closed, be polite, be professional, just respectfully decline to answer any questions if confronted without first speaking to an experienced criminal defense attorney. An experienced criminal defense attorney at all levels of these cases, from the pre-file investigation phase where you might be contacted by the cops, where you might be getting a text message from this person and say, hey, why'd you do that to me last night, or remember that date when you raped me? Ignore it. Either ignore it or say, hey, here's my attorney's phone number, please contact him or her. All the way through court, all the way through felony preliminary hearings, all the way through trial, it is essential to have an attorney who's been there, who's done that. And, some people can't afford the most experienced attorneys, and that's fine. There's attorneys out there that are pretty good at what they do with a little bit less experience, if not a lot less experience. But it's essential that if you can't afford a top-notch attorney, and if you're going to, make an economical decision, and that's understandable in a lot of situations, that you make sure your attorney either at least has the baseline experience for these types of cases, or will be able to be smart enough and not stubborn enough or not prideful enough to not associate themselves with someone who knows what they're doing. Far too often we see these types of cases, and people take it for granted, and they don't want to spend a lot of money and hire an attorney, and they wind up hiring someone that doesn't know what they're doing. And they're spending good money, but they're not getting the good results and the quality of representation they deserve. So whether you're charged with date rape or any rape for that matter, general rules apply. Don't admit to anything. Don't necessarily lie about it. Just keep your mouth closed. Contact an experienced attorney right away. And then let the prosecution have to prove that even an act of sexual intercourse or sexual relations occurred, and let them have to prove that it was non-consensual before they get that conviction.